Yeah. Hi, Steve. Morning. Good morning, sir. Morning. Sir, morning. Morning.
From the main list, item number 1.
Yes, sir. May I please, Your Worship. This is an appeal, my lord, of three appellants from.
Did everything condoned?
Yes, already,
Yes.
already admitted, yes.
You are ready to proceed with the appeal?
Yes.
Yes. Ready?
It's up to my lordship. So far, my sir, I'm ready.
Very good. Yes.
Before I proceed, my lord, I'll proceed from the point that regarding that the accused person, the educational qualification and the academic background, Your Honor. Because I have placed also in my memorandum also that this appellant are illiterate and they are very, very poor, my lord.
That doesn't change the nature of the offence. Conviction under which provision?
Under 302.
302.
Yes, madam.
Yes.
Yes, it will not, but of course it will have an impact because in the course of submission, I have to refer regarding all those things.
Yes.
Because
So has been sentenced to life?
yes, madam. Madam,
Yes.
sentence for life. So the first contention, madam, is that these appellants are illiterate, madam, and they are also of a very, very poor, and it is on record, so madam, that their income is only around 500 per month, madam.
I'm sorry, not able to follow you clearly. What we understand is that they are poor.
Poor.
Yes.
And from
One
the
appellant.
from the
Even
record
if
of
it
the
is
police
poor,
also.
how does that matter? In the commission of the offence or the sentence, we have no discretion.
No, that I fully understand also, madam.
Yes.
But because the background also, I have to
Yes.
be brought before your lordship. Then in this case, madam, their income is below 500. That means they are object property, the whole family. Now, madam, this case was framed under section 302 and 34 and read with 34, madam. Common participation. And in the record, my lord, the charge was framed at page 26 of the paper book, my lord.
There are how many appellants? Different appeals? Three?
3 appeals.
All part of the same sentence.
Yes, my lord, all parts in sentence.
Who is appearing for the other appellants?
I'm appealing for all appellants.
You are appearing for all appellants.
Yes, my lord.
But you are taking a risk because you cannot contradict the case of one against the other.
Yes, my lord.
That risk you are taking.
Yes. Because the same evidence also they have taken.
Maybe, but you cannot be heard to apportion blame to anybody else. That's why common appeal and common counsel cannot be there. If you cannot say that he did it, I did not do it.
Yes.
You have to say none of us did it.
None of us.
None of us did it.
That is my craft.
That's your case.
Yes,
because you can never say he did it, I did not do it, or he was there, I was not there.
Yes, my lord.
Yes.
That I fully understand, my lord.
Page
26, my lord. The type copy is in page 27, my lord. Page 27 is type copy.
27. Charge sheet. Yes. Charges were brought against 5 persons
Yes, 2 died.
who died.
Yes, my lord.
Yes.
In this case, my lord, the charge was framed by the session judge, the Bikri, and then may I read your lord, the charge?
Yes.
Hereby charge you, Mudrakai, Maina, Pali Mula Rakai, Mulu Rakai, Tum Rakai, and Yolang Rakai.
No, there is no need reading the charge sheet. There is nothing in that. Just indicate what are your points.
My point there, my
And
lord,
then take us through the evidence and everything else as you want.
I'll come to that, my lord.
Yes.
I'll be very quick for as far as charging concerned.
Yes.
My lord, the first contention regarding the charge, my lord. Here, if you go through the last line of the charge read about and explained to the accused by Shri R.B. Hing, advocate in Panar language, and accused Muro Rakai, Yolong Rakai, and Mut Rakai, pleaded guilty, while accused Jilip Thermang pleaded not guilty. That is key.
There is one page missing.
In the side, my lord. The time the side.
Oh, on the side, yes.
On the side.
And Tum Rapat pleaded guilty, while accused Dilip pleaded not guilty in Panar language.
You know.
So, 1, 2, 3, 4. 4 pleaded guilty. And 1 did not plead guilty. 1 pleaded not guilty.
Yeah, Dilip Sharma. That is,
Yes.
that died also, my lord. That one.
Yes.
That died. So, if you go through the child read about and explained to the accused by the R.B. Hing, advocate in Panar language, and accused Mulur Yolang Mut and Tum Rakai pleaded guilty, while accused Dilip Sharma pleaded not guilty. So, my lord, my first contention in this case, my lord, it clearly shows that these people, they don't understand, my lord, regarding the charge, my lord. There is no one to explain them. Nobody explained them. There is nothing here to show that has been explained to them in their language, my lord.
Yes.
And that they have simply put their thumb impression, my lord. Nobody explained that. It is the case of the prosecution that it has been, the charge was read about accused by R.B. Hing, advocate, my lord. This advocate, my lord, is advocate of the accused, of course, my lord. But the fact remains, my lord, that nobody explained to them. The court also did not explain because he doesn't know, and then that counsel also did not explain. Nobody explained to them regarding that charge. And if it is done by that defense, my lord, so it amounts to that if we go to 281, 345, then he amount to be an interpreter only, my lord. So if he is interpreter, my lord, then he is bound to do it truthfully. And if that is the case, then in this case, my lord, he has not administered an oath to him. No oath has been taken by the
Yes.
Let
us see what the evidence is.
We'll come to that, my lord. First, I want to explain that. I'll come to that. Because in this case, even regarding the evidence, there is no evidence at all. The Leonard District and Session Judge decided this case on the confession only, my lord, and nothing else.
Let us see. Yes. Show us the evidence.
No, I'll come to that, my lord. Because as per 282 also, my lord, interpreter is required.
We come to that. Show us the evidence.
Page 1, page 2. Now the evidence will come from page 31 and 1, my lord. 31.
Yes.
I know the case as the deceased is the son of my cousin, sister of Kashalbi Rakai.
Yes.
And the house of the deceased is in the compound as that of my house. On the day of the incident, I was at home as we were having puja in our house, and it was dark. My lord, at the time when the deceased came to my house and picked up quarrel in people who had come to attend puja in our house. And we are Nyamtre, that means indigenous religion, my lord. Nyamtre, indigenous religion. And the accused person, namely Umud Rakai, Uthum Rakai, Umulo Rakai, Uyora Rakai, pulled out the deceased from the house. Then she explained that Thum Rakai and Muro Rakai are the son of my elder sister. Accused Mud Rakai is my younger brother, and Yulang Rakai is my son. When the accused pulled up the deceased out of the house for creating trouble during puja time, I did not go and see what happened, as I myself was preoccupied with the puja ritual at that time. Then she stated, my lord, I do not know.
Yes, carry on.
Then, my Lord, I do not know who killed um, Salon Rakai. That is the deceased, my Lord. Then, continue, my Lord. The mother of deceased is Srimati Sharbi Rakai, has died 2 months back. So this witness, my Lord, did not know who killed Salon Rakai. The Salon Rakai is the son of Sharbi Rakai, my Lord. And Sharbi,
Carry on.
then, my Lord, the defense counsel, he declined to cross.
Yes.
Now, my Lord, I'll come to the PW2, my Lord. PW2, page 35, my Lord. The deceased is my cousin brother, and PW1 is my sister. The deceased and the accused, Mut Rakai, Tum Yolang Rakai, are related as the deceased is their uncle. And accused, they are my sister's son, and we all stay in the same compound. On the day of the incident, we were having puja in Pidlu1 house. When the deceased Salon came to the house of Pidlu1 and created trouble with the people attending the puja, and picked up quarrel with them. The ladies were busy with the puja preparation and ritual. The deceased was pulled out of the house, and I also not know by whom. Was pulled out of the house, and I do not know by whom, my Lord. And I also not know how the accused was killed. So she does not know also. The mother of the deceased, Sharbi Rakakai, is my auntie, and she has expired about 2 months back in her newly built house at Mudok, Napiang. So, this PW2, my Lord, did not support the statement of PW1 that this appellant are the people who pulled out.
All right. Please come to the 164 statement. Of the four of them, where are the 164 statements?
Of the
164 statements. Four of them made 164 statements. Where are they? First appeal is Mutlaka. Muloraka.
Muraraka, page 100.
Where is the 164?
One hundred, madam. Page 100. It's type copy.
Type copy is page 100.
That is confession of.
Yes. Come to page 102.
Yes, madam.
Look at his statement.
From where did the police arrest you, on what time and date?
No. Forget all that. Come to his statement under paragraph 7.
7. Salarakai killed my mother when I was young, about 13 years ago, and we did not do anything because we were small, and we just forget it. But this man always pick up trouble. This man pick up trouble with us often when he was drunk, but most of the time we avoid and ran away. Last week, during performance of comedy right, he came to our house and started to create trouble, and we thought of finishing him off, but the ladies did not allow us to do because of our family right. But again on 10/7/06, after he came from somebody's house, got drunk, and he came to our house and started to threaten the sister of the house. And that moment, myself, Mut, Tum, and Yolang came of the house and beat him up. Then we pulled him to the road and killed him with stick, stone, and hammer. After that, the ladies went and reported to the police, and the police came and covered the dead body. Madam.
Yes, confession. Where is the 313?
No, my lord, I'll come to it. Regarding this confession, my lord, that it was not done according to the procedure data.
We'll look at later, but let us see the basic facts. Where is the 313?
132, my lord.
132.
Yes, my lord. First question, my lord. It's transferred from the evidence of PD1 that she knew the case of the
That is irrelevant.
Then has denied, my lord.
Come to 14. Question 14. And he says, I do not remember. He does not even deny it.
It also transcribed from the evidence of PD7 that each of you was brought to his chamber, one after the other, and
Whatever is there, that's waste of time. He does not say he denies it. He does say, I do not remember.
He said, I did not confess to anyone. Para 16, my lord.
That does not happen. It's not so easy.
But anyway,
His father says that he pulled the victim out.
but that is that.
Father does not say I saw the killing, but the father says there was puja at home. He came, he created trouble, he was pulled out by these people, he identified them. And he says that I have no knowledge, I was not there on the day. What is the alibi? Nothing, sir.
No, because here,
Whatever you do will be waste of time, nothing.
no matter, I have to specify about it regarding the confession, or it's not correct.
Absolutely correct. Absolutely correct. We've seen the only thing was when they were sent for reflection, there may have been a policeman over there. That does not detract from it. They could have said we did not say the statement, we did not make the statement. They did not cross-examine the mistake on this.
I did not confess to anyone, my lord, has stated here.
It said, I do not remember.
No, I did not confess.
That is much later.
No, in paragraph 16, it's very clear.
That is much later. 14, 15, answer is, I do not remember. You have to take it as a whole.
That's why, my lord, if he is taken as a whole, then the confession also.
Nothing. No respite, no.
Because in this case, the confession is not
You cross whatever else you have to show. We don't need anything else. On every aspect, you will allow you to argue on the monetary thing, on the confession, on the nothing. Clear-cut case.
It's not a clear-cut case, my lord. Because
That's your opinion, sir. But the pen ultimately is in our hand.
that's true, Your Honor. That's very true.
That's your opinion.
Yes.
And that cannot be a reasonable opinion on the basis of the evidence.
I am not saying my opinion, my lord. That is what appears from the record, my lord.
It does not. It does not.
Right.
If confessed, you do not cross-examine the magistrate before whom you confessed. There is nothing about confession in the cross-examination.
The magistrate cross. For the magistrate,
Yes, there is nothing in the cross-examination. We've seen the cross-examination. There is nothing in the cross-examination. Come to page 44.
no, because the confession, that's why, my lord, I'll satisfy your lordship regarding to confession.
And the casual retraction in 313 is not a retraction of confession. Confession can be retracted. There's no problem. But not a casual retraction in 313. Look at the surrounding circumstances. The father of one of the accused says, my son was also there, he pulled out the disease.
There's no father here, madam.
There is a father.
No.
Last one, Yalong's father is there.
No, not father.
PW1.
PW1 is not the father.
PW1 is the last one's number 4's father.
It's not
Come
the father.
to PW1, page 31.
PW1 is not the father, madam. PW1 is page 31.
Sons of my Yolun Rakait is my son.
That is the mother, not the father.
Please come to page 31.
Yes.
Mut Rakait, Tum Rakait, Mulu Rakait, Yolun Rakait pulled out the receipt from the house. Accused Tum Rakait and Mulu Rakait are the sons of my elder sister.
Yes.
Accused Mut Rakait is my younger brother.
Yes.
And Yolun Rakait is my son.
That's what, it's a mother, madam, this one. It's a mother.
Whatever it is, mother or father? Mother.
Mother.
Mother says that my son was one of the people who pulled out the accused. Accused came and created a problem.
Our statement was not corroborated by anybody, madam. Nobody corroborated.
Need not be. Anyway, tell us, show us the law. How can law let you escape when the evidence is like this?
And in this case also, madam, the case diary is required, madam.
So we asked you whether you were required to. Now, after starting, we will not let you go. Now it is news.
No, because
No, sir. Not at this stage. We gave you the option at the beginning. You were ready to proceed with the matter. Now we are ready to deliver judgment. After you finish whatever you have to show, we will give you all the time. We will not.
because my main condition, madam, is that
You have 3 contentions. First contention is that they are illiterate and poor. They did not understand the consequence of the charge being explained to them.
yes.
You also say that the charge was not explained to them by an interpreter. Charge was explained to them by their counsel. This should not have been, they did not understand. Very well, accept it. Why did they then make 164 statement? Clear 164 statement. Now you say in 164 statement that was not recorded properly. If it was not recorded properly, that is admission that it was recorded.
He was not according to law, madam. Because there are numerous decisions of the Supreme Court, madam, regarding this.
One can understand you saying that this is not in accordance with law. But your 313 statement is, 1, I do not remember. Second, I do not remember. Third, I did not make confession.
But that is
When you did not cross-examine it was not no part of their obligation to produce the magistrate. Magistrate is not required. Section 80 provides for shall presume. But they produced the magistrate. You did not cross-examine the magistrate on the point of your, it could have been poor advocacy. But then we have to look at how it proceeded. The magistrate has no motive. The magistrate, who is a Khasi gentleman, says that I speak Panad language completely well, and indicates in his cross-examination that everything was explained and he got the answer voluntarily. Why should we doubt him? When the instruction, the statutory instruction is shall presume.
Over and above, and that's why I say it's not according to law. He did not even make a memorandum and read to him.
He said read over and explained.
That is not memorandum. I've done in this.
Those are technical things. Those are technical things for which the evidence is not thrown away. What do you require from the case diary?
Because the FIR was submitted by Sharbi, the mother of the deceased, and this has not been brought before the court, madam.
After the appeals are heard to some extent, counsel for the appellants submits that the case diary may be necessary, paragraph, even though it cannot be appreciated at this stage as to how the case diary may be relevant, since a plea in such regard is made, the matter is adjourned for 4 weeks, paragraph, produce a case diary.
Lordship, let me try. This is a very...
The state will produce the case diary within a fortnight, full stop. Leave is given to the appellants, all three appeals together. Huh? Leave is given to the appellants to look into the case diary in the presence of an officer of the court. So it will be deposited in court, you take a look at it. Yes.
Lordship, I'll have to inquire. It might be with the lower court record also, the case diary, Lordship.
It will also be open to both the state and the appellants to look into the lower court records which have been brought to this court. Yes.
You ask me a question.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
What is this matter, sir?
This is matter connected with the gradation list.
Sorry?
Gradation list, interesting gradation list. Petitioner was appointed earlier to respond number 567, almost 2 months. So he claimed that he's the person to rightly.
Are you ready to finish it now?
No, not.
Mr. Ahmed, Mr. Khan? When?
It come to up 2 weeks.
Since the appellant seeks no limitation,
No.
since the appellant seeks a fortnight's accommodation, comma, let the matter appear 3 weeks hence for final hearing.
But my lord, I've got an interim prayer also.
Yes.
That this.
No. Without looking at it, we don't.
My lord,
Interim prayer, if you press it, we'll hear out the appeal and we'll dispose of the appeal. Without, for the asking, we don't grant a stay. One learned judge has gone into the matter, has applied his judicial mind and arrived at a final conclusion. It's not something that we tinker with in a hurry. Yes. Call on the next matter, please.
Item number 2.
Yes.
May it please your lordships.
Yes, madam.
Your lordships, here there's a delay of 41 days.
That's all right. What is the appeal about?
Your lordship, here the appellant was initially appointed as a casual cleaner in the office of the respondents in the year 1991.
Casual what?
Cleaner, your lordship.
Tailor.
Yes, your lordship. In the year 1993.
Assam Rifles.
No, your lordship.
Then
PWD.
PWD.
Yes, your lordship.
And then?
Then, your lordship, if I may take your lordships to page 35.
No, we'll come to it. Just tell us what the story is. then
Yes,
we'll-
your lordship. So, initially, your lordship, she was appointed as a casual cleaner. Then, in the year 2003 and 2006, there was a list of incumbents proposed for regularization, and her name was also reflected in both the lists, both 2003 and 2006. However, your lordship, she was not regularized. Thereafter, your lordship, in the year 2019, on retirement of one of the cleaner in the office, your lordship, she had addressed a representation before the office of the respondent.
Unfortunately, if you don't come within paragraph 53 of Umadevi, you have no right. 2003 and 2006 lists were prepared before Umadevi judgment was delivered. In 2009, Umadevi was already there.
Yes, your lordship.
Unless you came within the exceptions in paragraph 53 of Umadevi, no regularization is possible.
Your lordship's paragraph 53, your lordship, also speaks about casual workers.
Yes, it does. But there are certain conditions
Yes,
in
Your
which those casual workers can be taken in. If you don't comply with those conditions, you don't come within the exception.
Your lordship, she's not covered under any interim.
If she's not covered, then she cannot be regularized, madam. That's the law of the land. After Umadevi, there was an attempt to dilute Umadevi. Then came Dayanandan, official liquidator. After Dayanandan, official liquidator, there's no escape from Umadevi.
But your lordship, in the letter rejecting her prayer for regularization, your lordship, they've only stated that her services does not fall under the work charge employment. That is the only ground, your lordship.
Whatever ground they may have given, she was taken in as a casual. She entered it with her eyes wide open that she was casual. There is some other scheme. That scheme does not apply over here.
Status, your lordship.
RCS.
RCW status, regular casual worker,
Yeah, regular casual worker, the 1986 scheme.
1996. Your lordship, even under that also, your lordship,
Even under that, there is no regularization, but some posts of that department are
50%.
kept reserved in certain cases, and they get certain other benefits like leave,
Yes.
like maybe lump sum payment upon retirement or something like that. They get some benefits, but not all benefits as a regular employee.
yes, your lordship. Your lordship, see, in view of that also, your lordship, in view of RCW scheme, your lordship, they ought to have at least considered her prayer for regularization because a post was vacant, your lordship.
Under the that scheme, 86 or 96 scheme, there's no regularization as such. Only a small percentage are allowed to participate in the recruitment process. and there's age relaxation for them, nothing else. But otherwise, the benefits are leave, some nominal. What is the learned judge held? Bring us to the operative part. Oh, she's got that. Paragraph 8.
Page 110.
Paragraph 8.
Paragraph 8.
They've been directed to consider you for the RCW scheme.
Yes, Your Lordship.
Where is your prayer in the writ petition, madam?
Page 29, Your Lordship.
29. Rule calling on required by direction for regular. Okay. So that cannot be done, but RCW scheme, they've been asked to consider. Consider that you've been asked to consider. You have not preferred an appeal. Consider the RCW scheme and issue a reply. We'll keep the matter after 15 days or 20 days. By then you decide on that aspect.
Lord, one aspect, my lord, whether she has filed a representation thereafter, my lord.
She is not required to. Now there is an order of court.
My lord.
You are a party to the proceedings and the order of court says you consider her. She does not have to do anything. She'll put her legs up and sit down.
My lord.
You have to respond to this. You've been given 3 months' time. What was the date of the order, madam?
20,
My lord, the
26, 2023.
So that's June.
Yes, Your Lordship.
So therefore 3 months is expiring now. We'll give you 3 weeks' time.
Lord, may I pray for 4 weeks?
No. The order gives you 3 months' time. You had enough time. Another 3 weeks will cover that.
My lord.
In view of the good ground shown, the delay of about 41 days in preferring the appeal is condoned and the appeal is taken on board. Paragraph. The grievance of the petitioner is that though the petitioner had obtained casual appointment in the Public Works Department of the state as a cleaner in the year 1991,
1993, Your Lordship.
in the year 1992,
3.
and the appellant,
Your Lordship.
and the
Your Lordship, if I may, Your Lordship, I'll just take you to one page, Your Lordship, page 84.
appellant will consider that we are not disposing of the appeal now. And the appellant's name figured in the list of probable candidates for regularization in 2003 and 2005,
2006.
2003 and 2006, her services were never regularized. Full stop. Paragraph. Though the prayer made in the writ petition was that the petitioner's services should be regularized after she had rendered a considerable period of time in service, the writ court only permitted the petitioner's case, the appellant's case, to be considered under the regular casual worker scheme
1996.
which is prevalent in the state. Full stop. Indeed, the judgment and order impugned dated June 2023 affords the state 3 months' time to consider the petitioner's case under the scheme. Full stop. Paragraph. It appears that the state has not communicated any decision in such regard to the petitioner. Full stop. Notwithstanding the petitioner's claim that she is entitled to regularization, the state should immediately consider the petitioner's case under the said scheme and communicate a reasoned decision to the petitioner, wherever I have said petitioner appellant, consider and communicate a reasoned decision in such regard to the appellant within 3 weeks from date, paragraph, let the matter appear 5 weeks hence for the appeal to be finally heard.
From the minutes, item number 1.
Yes, sir. Good to see you.
Lordship, Lordship, can you hear me, Lordship?
Yes, absolutely fine.
Lordship, the state government has passed an order rectifying, taking remedial steps in regard to the order which was passed by this honorable court. On
What is the order, sir?
Lordship, I had copy.
You got a copy of the order? Right. So it's done. Have you got a copy of it, madam?
Yes, yes,
I have
my
Then
lord.
announce the order.
Yes, my lord. I have a written submission, my lord. My lord, the order was issued by the respondents are not corrected measures, and these are only issued to avoid the legal complication, my lord. My lord, the dissolution orders has only been cancelled without restoring the appellant governing bodies, my lord. Further, the order that was issued.
Madam, the effect of the order dated 29/9 and the subsequent order being annulled, cancelled, is that the governing body stands restored by automatic. We record it that the governing body stands restored, but they will have authority now in accordance with law to deal with the matter in accordance with the grant-in-aid code. So that naturally follows from here.
Then, my lord, in my the appeal may be disposed in my senior present, my lord.
We will give him a day, but nothing remains.
Yes, my lord.
Nothing remains. It is heartening to note that.
Lordship, may I interrupt, Lordship? For
Yes, sir.
Your Lordship, promise. Lordship, in fact, what has transpired is that, Lordship, we have humbly bowed down before the suggestion made by this honorable court.
Sir, we are not doing, Mr. Raddy, we are not doing anything. We are just recording that this has been passed, and we are recording what is the consequence of that. We are not doing anything. We are formally not disposing of the appeal. We are keeping the matter after 4 weeks. We are not doing anything. And you will be at liberty to take steps in accordance with law. We will provide for it.
Lordship.
It is heartening to note that following the order dated August 31, 2023, the state of Manipur has graciously passed an order on September 1, 2023, by which the impugned government order of September 29, 2021, pertaining to the dissolution of the Naurem Birari College in Khundrakpam has been cancelled. Full stop. Paragraph 4 of the recent government order of September 1, 2023, issued by the Joint Secretary, bracket, Higher and Technical Education, bracket, Government of Manipur, expressly records as follows, colon. Next line, open quote. Now, therefore, the Governor of Manipur is hereby pleased to cancel the said G capital, O capital, government order number 10/26/2017 dash, bracket, capital HE, bracket close, bracket start, capital P, small t, full stop, bracket closed, dated 29-09-2021 with immediate effect and convey the approval to the Directorate of University and Higher Education, Government of Manipur, to issue an appropriate order in this regard. Full stop. Close quote. Doubtless, the relevant order from the appropriate order from the Directorate of University and Higher Education will follow. Full stop. Since the governing body of the relevant college stood dissolved by the government order of September 29, 2021, which has now been cancelled, the governing body stands restored. Full stop. Paragraph. However, it will be open to the state of Manipur to take further steps in accordance with law, further steps in respect of the relevant college in accordance with law, particularly in terms of the provisions of the Granting Aid Code operating in such state. Full stop. Paragraph. Since the appellant says that the appeal should be kept pending, see the steps taken to await the immediate future steps taken by the state, let the appeal now appear 4 weeks hence. Full stop. Paragraph. The pendency of the appeal will be without prejudice to the rights and contentions of both the appellant and the state. Thank you. Keep this as part of the record in the order first. Thank you, Mr. Reddy.
Item number 3.
Lordship, we have received some instructions with regard to the filing of the supplementary affidavit. But those instructions, Lordship, are not sufficient. We need little more accommodation to get further information.
The respondent seek an accommodation, let the matter appear 3 weeks hence. Paragraph. Leave is given to the respondents to use a supplementary affidavit to be filed within a fortnight from date. Full stop. A copy of the supplementary affidavit must be made over to advocate for the petitioner immediately for the petitioner to use a reply thereto before the matter is next taken up.
Highly.
Yes.
Item number 4.
3 and 4 are connected, my lord.
Very well.
Item number 5.
What is the matter about Dr. Madhikar?
Well, this is with regard to appointment of a scientist, my lord, in NILIT, that is National Institute of Electronics. Earlier it was called DOES Society, my lord. Now here the issue, my lord.
You are appealing for?
Your Lordship, in this case, I am appearing for the respondent and the Learned Conduct Council on his legs, Your Lordships. So, if Your Lordships can kindly accommodate me for a week, Your Lordship.
There is a solitary respondent.
Solitary.
Very well. Since the respondent seeks an accommodation, let the matter stand over for a fortnight. Give a date.
Deeply appreciated.
Record the appearance, please, for the respondent. That's all.